Okay, okay. Take your seats. Settle down, settle down. Welcome to the Road to Concord 101. This class is about all things connected to the path of history leading from Mount Sinai to Lexington Green and the individual liberty and freedom of man. If you're in the wrong place, feel free to get up and go see the registrar's office about dropping this class, preferably before you meet the professor. In the event you do not already know this, your professor is Joe Bakanovic, and he has a bit of a reputation on campus. He is most definitely an acquired taste, but if you can learn to tolerate him, he will make you better at defending your position, whatever it may be. I'm T.A. Charlie. I'm here to help the professor, but more importantly, you. We encourage you to take notes, and if you have questions, feel free to call. If you'd like the number, please email us. You can also post your questions in the comments, and we'll get the professor's attention. Part of my job is to let you know a little bit about your professor. As I said earlier, the professor has that bit of a reputation on campus. Not all of it is good. Let me help explain a little with a story about how I came to be the professor's TA. I was invited to attend one of his classes. My first impression of the professor was that he was an egotistical, narcissistic know-it-all. My intent after only a few minutes of class was never to attend another class with this professor. But after class, Professor Joe came up to me and thanked me for my class participation and told me that my perspective was valuable, and he asked me to keep coming to class. This actually took me back a little. To me, he seemed inconsistent. What was I to do? I decided to continue coming to his classes. As I did, I actually started doing what he does encourage students to do. Check behind him and see if what he is teaching is actually correct. I have done this over and over again, and generally speaking, I found what he teaches to be backed by sound, valid, and rational arguments from reputable sources. When I have challenged him and provided a sound, valid, and rational argument in opposition to his current position, he immediately changed his position and thanked me for correcting him. Why do I tell you all this? Professor Joe is a little rough around the edges, especially in the way he delivers his content. But if you stick with him and listen to what he teaches and then go and check his sources, you will likely find, as I did, he will help you better understand the world around you and help you to think better and hopefully to live better. At least that is our hope. One last note. This class builds on itself. Therefore, it is important to attend class regularly. We will not always have time to go over previously covered material. If you are new, we suggest you watch our older classes. We've created playlists to help you with those things we feel are of special importance. Now, let's get started.
Good morning. Welcome to the Road to Concord. It is Thursday, November 20th, 2025, and I am your professor, Joe Bakanovic. Real quick, some housekeeping to do before we get going. I am still struggling. I think I found a way to actually post recordings on StreamYard and have them play. I will know for sure by tomorrow. So if you're with us tomorrow, you'll find out what we're doing for next week. Otherwise, I'll probably put something up on the Facebook pages, and I'll try to get to those who are interested. Other news here today. My computer is doing some wonky things here, so I'm subject to glitching out at any moment. If that happens, Charlie and Natasha will entertain you while I try to get back on. If I can't, I'll text them, let them know. It made me change the way I had. Charlie, did you have something? I'm sorry, I just realized you were on there. Did you have something you wanted to say?
Nope, I just didn't pull myself out of screen there. I was
no problem.
Busy doing all the other stuff and didn't catch it.
So normally I like to put up things on the screen for you and all, but it seems that the more windows I play with today, the more likely my computer is to say, see ya. So I'm not going to do a lot of that today. It caused me to pivot a little bit, but I'll still be able to get to the bulk of what I want to share with you today. I want to talk about our judicial system. Just going to get right into this today. Toward the end of the show, I'm going to give you a little bit of a civics lesson on how it's supposed to work. But our judicial system is turned to crap. Uh-oh, I said the C word. It's a good thing I'm feeling subdued today, or I might be screaming and yelling and crud. Yes, that's a better word, Natasha, but it still doesn't help because you know what I want to say. We have judges who are constantly releasing habitual lawbreakers with little or no bail. And these people go on to do more crimes. There's a story in the news just yesterday. Guy's been arrested like 90-something times. Judge let him go again, no bail. And he set somebody on fire on a subway. That judge should stand trial for murder, or at least whatever they finally charge that guy with. The judge should be charged as well. This idea that our judges should be immune from the consequences of their actions we've got to do something with this. The idea that anybody in government is immune, it's a violation of natural law and natural rights. I cannot give myself sovereign immunity from the laws of nature. I can't. I'm not the lawgiver. Therefore, I cannot give that right or authority to anybody in government. We, the people, cannot get together and say, okay, well, we're going to set up a government. And in this case, you're not subject to the laws of natural, the restraints of natural law and natural rights, because you're going to be above it. You can't do that. Not that you shouldn't. You can't. Not under that system of thinking. It's just not possible because you don't have that power or authority to give. So this idea that the government should have sovereign immunity, I understand that it's necessary in some instances, but it should be extremely curtailed. You should, like I got the right to free speech. Yes, but you do not have a right from the consequences of your free speech. So if I claim that I have the right to incite a riot and I end up inciting a riot and somebody wants to sue me for the damages that were incurred, I should be held liable for the damages that I helped incur with my speech. Our judges should be held liable for the damages incurred by their rulings. Maybe they would be more responsible. They're also extending legal protections to criminals who are outside of their jurisdictions. And by that, you'll have to hold on for a little while till we get to jurisdiction, but it's more than people think it is. They do not have the right to extend every constitutional protection to an illegal alien. Under the 14th Amendment, it says that applies to those who are within the jurisdiction of the government. But if you are an illegal alien, you are still a citizen of the nation from which you infiltrated ours. You're still under their jurisdiction. You're subject to ours, but you are not under it. Now, what do I mean by that? I mean, we have the right to arrest you and enforce our laws. You're subject to our laws, but you're not under them. In other words, you don't have the protections as a citizen. You are not a citizen. So the United States Constitution does not apply to you. Shouldn't. Now, because of stare decisis, it's been expanded that way. We'll get to that later. But these judges are giving protections to people who do not have those, not legally, should not have those protections. And there are other people who should have those protections and legally do are being denied. We have a two-tiered judicial system in this country. The judges are being selective in how they apply the law and to who they apply it, and even how the cases are assigned to which judge. Our system is corrupt, thoroughly corrupted, to the point where it's time to scrap it and start all over. I'm serious about a constitutional convention, and if not, secession. We've got to do something, folks, because the keep on keeping on. You keep banging your head against the wall, all you're going to do is die, or at least get a severe headache. And if we keep doing the same thing we've always done, thinking it's going to change in the future and we're going to get a different result, that's the operational definition of insanity. So if we elect more Republicans, Joe, that's keep on doing what we've always done. The Republicans won't even censure a member of Congress who violated the Constitution. Oh, well, here's my principled thinking on that. Your principled thinking is you want to protect yourself from the time when you do something that you could get hit. Like I said, I've got to stay subdued today. Our judges are also refusing relief, legal relief, for those people who have legitimate grievances. So if I've got an illegal alien in this country who is soaking up all of my tax dollars with their welfare programs, that's a legitimate grievance by every taxpayer in this country. I should be able to sue over that. Go try it. You're going to be told you don't have standing. But if the illegal alien, who is not a citizen of this country, comes and says, hey, I've got a right to your taxpaying dollars, and Trump took them away, they somehow or another have right of standing. Folks, let me put this very simple for you. Just because you happen to be in this country doesn't mean you have the right to sue this country for anything you wish. Otherwise, all I have to do is get a travel visa, come here from Timbuktu, and while I'm visiting, file a lawsuit that says you owe me everything I want to collect, even though your visa says you have to be gone before your first payment would be made. That's lawlessness. And that's where our judges, excuse me, but that's what's happened with our judges. I'm in a very irritable mood over this subject. We have sweeping rulings that are outside these judges' scope of the case, outside their jurisdictions, outside their authority to make. We have refusal to hear legitimate cases. And then if the case does get taken, the judges are refusing to allow evidence, discovery, or legal strategies. And then on the other hand, they'll allow some cases they should not be hearing. And in those cases, they will allow evidence that should not be presented and legal strategies that should not be allowed under normal legal precedents. And heck, sometimes they even help one side or the other with their case. They refuse to recuse themselves when they clearly have a conflict of interest, actively side with one case over the other. Watch that case with Comey right now. That judge has already decided that case. Why did it even get to a politically appointed judge? These judges are ignoring settled law. They're ignoring rulings from higher courts. How is it that they are still on the bench? Well, I forgot. We've got to elect more Republicans. That's the answer to everything. More Republicans. Doesn't matter how many crooked Republicans I give you, the Republicans are still going to side with the deep state because they are a part of the deep state. I know. Joe, you're a conspiracy theorist. You're against MAGA and all this other good stuff. No, I'm a constitutionalist. I am for the individual rights and liberties of man and the preservation of our system as it was designed to operate. And I don't give a rat's rip about your party. I'm not allegiant to the party, especially a freaking corporation. So we have judges that are ignoring and overruling the will of the people. They're usurping the executive and legislative authority and powers. They're giving orders that override the executive and the legislators' will and their elected authority. Essentially, the judiciary, at least as far as the left is concerned, has become the focal point of government authority and power. It's where you go when you want to do something that's not legal and you want to change the law where you can't get an amendment or a law passed. It's corruption of the system. And a lot of it is being done to get around the restraints of our system as it was designed. That, folks, is the legal definition of subversion. It is illegal. They should be arrested. Well, Joe, you got to impeach them first. No, I don't. I do not have to impeach a judge before I can arrest them for corruption. There's only one person in this country that has that type of immunity. Well, Joe, the Constitution says you can't arrest a congressman on his way to Congress for a session. No, I can't. Not on their way. But the Constitution doesn't says I can't wait for them, and when they get there, then I can arrest them. Doesn't say I can't do that. Doesn't say I can't arrest them as soon as that session is adjourned. That's why if a judge is caught in a sting and taking bribes, they don't impeach that judge before they prosecute him. They just arrest him and put him in jail. We have forgotten how our system is supposed to work. Now, I'm going to try something. This is kind of dangerous, folks, but we'll see what the computer says today. This is the Rutherford Institute. It's June 12th, 2024. Timely Lessons About Tyranny from the Father of the Constitution by John and Nisha Whitehead. And he quotes James Madison, says, "Take alarm at the first experiment on our liberties." Experiment, meaning the first attack to see what you can, what piece of our liberty you can take away incrementally. And he goes through the history of Madison. But the reason I put this up here is, you'll see in a second here, I like his Madison quotes. "The accumulation of all power, legislative, executive, and judiciary, in the same hands, whether of one or a few, or even a many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny." The tyranny of the judiciary today is what we have. And before the end of the show, I'll prove it to you. The legal system in this country has done something that is unconstitutional, and we operate as though it's a matter of settled law, and it isn't. It's unconstitutional. It's illegal. But this is what gives them the authority to basically be all branches of the government within one unelected and unaccountable system, the judges. Madison also said, "The people are the only legitimate fountain of power, and it is from them that the constitutional charter, under which the several branches of government hold their power, is derived." Notice he called it a charter. Oh boy, that's an important word we'll have to come back to not next week, when we come back from the break and we're talking about the Declaration of Independence. And then he also said, "If men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this: you must first enable the government to control the government, in the next place oblige it to control itself, or control the governed and then control itself. And then also, a standing military force with an overgrown executive will not long be safe companions to liberty. The means of defense against foreign danger have been always the instrument of tyranny at home." Now, you think that doesn't apply today to our standing military. I'm thinking this is the FBI, the CIA, the NSA, all forms of intelligence community, and the police force, which has been militarized. You see, you've got federal police agencies that are not constitutional, that are essentially paramilitary organizations. So that falls directly under what Madison is warning against. He says, wherever the real power in a government lies, there is the danger of oppression. Right now, it seems to be with the judiciary. Madison also says, knowledge will forever govern ignorance, and a people who mean to be their own governors must arm themselves with the power which knowledge gives. Hence this show, because you did not get knowledge in school, whether it be public school or college. At least very few of us did. Most of my most cherished understandings I had to teach myself. And then finally, James Madison says, "I believe there are more instances of abridgment of freedom of the people by gradual and silent encroachments of those in power than by violent and sudden usurpations." In other words, I believe progressivism is more a danger than revolution. And this article goes on. It says, first, the maxim that power corrupts is an absolute truth. And it does. Power corrupts, absolutely. So then the second principle is that government primarily exists to secure rights, an idea that is central to constitutionalism. Correct. It's expressed in the Declaration of Independence. The third principle revolves around the belief that no one is above the law, not even those who make the law. Hence, this idea of sovereign immunity is a violation of that third principle. Fourth, separation of powers ensures that no single authority is entrusted with all the powers of government. Well, the judges have given them themselves that authority. They did. And Congress acceded to it. Said, okay, yeah, you have that. And the executive has said, yeah, okay, we'll listen to that. So essentially, the Supreme Court and the judiciary, the federal judiciary, has said, we're going to be the dictators of this country, and we will allow you, elected people in Congress and the president, to pretend to be in charge so long as you do what we tell you to do. I will prove that to you before the end of the show. Fifth, a system of checks and balances essential if a constitutional government is to succeed, strengthens the separation of powers and prevents legislative despotism. Yes, but the courts, as you will see at the end of the show, the courts have destroyed that separation of powers, and everybody else is going along with it. I've told you that President Trump is doing things he should not be doing by constantly appealing to the court. Oh, please let me do this, court. Please let me do this. I'm sick and tired of him doing this. I'm sick and tired of every president that's ever done that. If the authority is clearly vested in the executive in the Constitution of the United States, and the Supreme Court says, well, you got to listen to us, tell the Supreme Court to sit and spin and ignore them. And when they go, oh, you're a tyrant, you're under, you say, hey, look, this document right here, U.S. Constitution says I have that authority. You don't. Now go away. And just tell them, go away. Open your mouth one more time, and you're going to find out that as the chief executive, I have the sole authority to charge you with subversion, prosecute you, and put your little happy booty in jail. It's called the rule of law. The sixth, representation allows the people to have a voice in government by sending elected representatives to do their bidding while avoiding the need of each and every citizen to vote on every issue considered by government. Unless, of course, the courts decide that the elected officials say that, you can't do that. People sent me here to do that, like Trump's agenda. Democracy. Trump is ruining democracy. The people elect him, say, go do this. He's doing it. In some cases, unconstitutionally. Yes, I'll give you that. But in a lot of cases, he's exercising his authority, and the courts are saying, no, can't do that. That's the undermining of democracy, which essentially, if a leftist says it, or anybody in the uniparty, that's Democrats and Republicans, what they mean is you're undermining their usurpation of constitutional authority. Finally, federalism is another constitutional device to limit the power of government by dividing power and thus preventing tyranny. Lincoln put an end to that. Federalism is when each of the states was considered to be sovereign unto itself. This is a series of quotes from Thomas Jefferson about the judiciary. I'm reading these so that you understand how much of a threat the founding fathers thought the judiciary was at the time of our founding and shortly thereafter. Now, this is a letter to Abigail Adams, John Adams' wife, September 11, 1804. This is all from Thomas Jefferson. Nothing in the Constitution has given them, the federal judges, a right to decide for the executive, more than the executive to decide for them. In other words, if they're going to tell the president what to do, the president can tell the court what to do. The opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves in their own sphere of action, but for the legislature and the executive also in their spheres, would make the judiciary a despotic branch. But this is exactly what the courts have done. Like I said, toward the end of the show, I will show you. I'll explain. The original error was, Jefferson again, the original error was in establishing a judiciary independent of the nation, in which from the citadel of the law can turn its guns on those they were meant to defend and control and fashion their proceedings to its own will. Well, this is not entirely true, Mr. Jefferson. Reread Section 3 of the Constitution of the United States, and you will see that they're not independent of the nation. It's just that Congress refuses to do its job. Rather than do its job, it would rather push woke agenda on you and argue over protecting illegal aliens. Jefferson also says our Constitution, intending to establish 3 departments, coordinated and independent that they might check and balance one another, it has given, according to this opinion, to one of them alone the right to prescribe rules for the government of others. and to that one to which is unelected by an independent of the nation, the Constitution, on this hypothesis, is merely a thing of wax in the hands of the judiciary, which they may twist and shape into any form they please. Letter to Judge Spencer Roane, September 6, 1819. And essentially what he's saying is the courts are going to be allowed to do whatever they want. There are no checks and balances on them. This is not true. But it does require, I understand where Jefferson is at. Jefferson is dealing with the practical, what's actually going to happen in real life, not the theoretical, what the Constitution allows. So he's not wrong, not in its practical sense, but he is wrong in a technical sense, and we'll address that in the second half of the hour. In a letter to William Jarvis, September 28, 1820, you seem to consider the judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place under the despotism of an oligarchy. Our judges are as honest as other men, and not more so, and their power is the more dangerous as they are in office for life and not responsible, as the other functionaries are, to the elective control. The Constitution has erected no such single tribunal, knowing that to whatever hands confided with corruptions of time and party, its members would become despots. This is what has happened. This is exactly what has happened. Now, it did not have to be and does not need to remain that way. And like I said, second half of the hour. The judiciary of the United States, this is a letter to Thomas Ritchie, December 25th, 1820. The judiciary of the United States is the subtle core of sappers and miners constantly working underground to undermine the foundations of our Confederate fabric. They are construing our Constitution from a coordination of general and special government to a general and supreme one alone. This will lay all things at their feet, and they are too well versed in English law to forget the maxim. And I'm not going to even try to read this here. It just basically means good judges have ample jurisdiction. A judiciary independent of a king or executive alone is a good thing, but independent of the will of the nation is a solecism, at least in Republican government. Essentially what he's saying is the judiciary, as it has made itself into, is the enemy of liberty. And he's right. And then in a letter to Charles Hammond, August 18, 1821, the germ of dissolution of our federal government is in the constitution of the federal judiciary. An irresponsible body, for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, incrementalism, also known as progressivism, and advancing its noiseless step like a thief over the field of jurisdiction until all shall be usurped. That's what's happened. And he, like I said, he's looking to the practical. He's looking to the history of England, and he's saying that this will be the end of our nation. And it has become so. Our Constitution is dead. The letter to Judge Spencer Roane, 1821. The great object of my fear is the federal judiciary. That body, like gravity, ever acting with noiseless foot and unalarming advance, gaining ground step by step, and holding what it gains, is engulfing insidiously the special government into the jaws of that which feeds them. In other words, it's destroying the executive and the legislative. This is 1821, folks, and he already sees this. Constitution was ratified in what, 1789? So this is 32 years later. In a letter to A. Corey, October 31, 1823, at the establishment of our Constitution, the judiciary bodies were supposed to be the most helpless and harmless members of government. As Alexander said and promised in the Federalist Papers, knowing full well he was lying his teeth off, his whatever. Experience, however, soon showed in what way they were to become the most dangerous, that the efficiency of the means provided for their removal gave them a freehold and irresponsibility in office, that their decisions, seeming to concern individual suitors only, pass silent and unheeded by the public at large, and that these decisions nevertheless become law by precedent, sapping by little and little the foundations of the Constitution and working its change by construction before anyone has perceived that the invisible and helpless worm has been busily employed in consuming its substance, In truth, man is not made to be trusted for life if secured against all liability to account. In other words, since they're not held accountable for what they've done, they are an evil. And he was right. Letter to Edward Livingston, March 25th, 1825. One single object will merit the endless gratitude of the society, that of restraining the judges from the usurping legislation. It's not just that, but the power of the executive as well. Compare to the following quote in Abraham Lincoln's first inaugural address. The candid citizen must confess that if the policy of government upon vital question affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made in ordinary legislation between parties in personal actions, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of the eminent tribunal, which is exactly what has happened. We have allowed the courts to basically take over. Are we back yet? I glitched here on this end. We're still not back.
Yeah, you froze for a second.
Hear me?
Your audio is coming through on my
right.
end, but your video's postcarding.
Everything is doing all sorts of I told you I hit too many windows. I still have a few to share real quick before the bottom of the hour break. This one here is just a story from Reuters. Judges keep blocking Trump's policies despite U.S. Supreme Court injunction curbs. Well, what the judges are, the Supreme Court said, you can't do this except with these exceptions. So now the judges are claiming all those exceptions. This is the Supreme Court trying to make it look like they're doing a good thing when they know darn well that they're giving a nod to the lower courts to keep doing what they're doing. Activist judges and overreach of judicial authority, a case for sedition. That's exactly what this is. This is one of the better articles I found today. Let me do this real quick. I'll throw it in the comments section. Natasha, if you could bop that over to Rumble for anybody who's interested. But it talks about the constitutional framework. The activist judges are undermining executive authority, the legal grounds for sedition and treason. And that right there is the part that we should focus on. I'm going to get to that after the break. But these judges are they're advocating an insurrection. They're seditious. They're subversive. This is treason. And it goes over the articles in section 3 of the U.S. Constitution. And it gives you precedent and remedies and things. Like I said, this is the single best article that I found in getting today's show ready. We've got the bottom of the hour break. When we come back, I want to give you a civics lesson, and it'll end with an explanation of what has happened and how to cure this. We'll see you in 3 minutes. All right, welcome back. All right, time for a little bit of a civics lesson. We have inherited a common law system, or common law heritage. It's a legal system based on judicial precedent. It's quasi-legislative in nature. Common law heritage came from our English origins, from England. Like I said, it's based on judicial precedent. It's quasi-legislative, and it potentially executive as well. Why do I say these things? Okay, you've heard this little term whenever we have a Supreme Court nominee or something, stare decisis. You hear that batted around. Does the judge believe in stare decisis? Why is this important? This is what I mean by the danger of the common law system. Stare decisis essentially means to stand by things decided. In other words, the precedent rules how you have to decide on this case. So if I have a case that is almost identical to a previous case, I've already got to decide in alignment with that previous decision. So if I have a case like Roe v. Wade and somebody sues, says, I got a right to abortion. Say, well, yep, Roe v. Wade says you have a constitutional right for abortion. No, you don't. You don't. That's a clear-cut slam dunk. You do not. Well, Joe, the Constitution doesn't speak to that. Yes, it does. The Constitution says that the United States was 12 years old when it was signed and ratified. Well, if the Constitution isn't the establishing document of the United States of America, then what is? The Declaration of Independence. And when you read the preamble of the Constitution, it will point you to the Declaration indirectly, but it does. And the Founding Fathers have said the Declaration is the founding legal document of this country, and it says we are created with a right to life. And the Constitution, Bill of Rights, says you may not have your life taken from you without due process. Well, there's no due process for the unborn in this country. Something you have the inalienable right to from the moment of creation. Ergo, bad ruling. But I'm not going to allow a judge that doesn't believe in stare decisis, because stare decisis decides, not the law. In other words, the judges are the law. They have become to the Constitution as the Pope is to the Bible and as the rabbis are to the Bible. They're going to be the arbiter of whatever it was meant to say. They get to decide. Even when the people who wrote the law, ratified it, put it in place, clearly told you what it meant. So this is the problem with stare decisis. Now, when used properly, it provides a continuity, a sort of predictability and certainty for the law, which allows us to operate and to function in a civilized society. So I'm not saying there's a problem with it per se. I'm saying there's a problem with the way corrupted men and women have used it. Stare decisis, even the Supreme Court has said it's not binding. It can be set aside when the remedies established by stare decisis are unworkable, changes in society, technology, etc., or the rulings were poorly argued. But the Supreme Court didn't, when it made that ruling, it didn't address what if the judge or the court that made that ruling was rogue. Not that it was poorly reasoned and poorly argued and everything. What if it was just flat out rogue, in direct contradiction to prior precedent? Well, that should have been in there too. It should be especially true in constitutional matters. In constitutional matters, now I'm not an enemy of stare decisis. I'm an enemy of those who abuse it. In constitutional matters, the original intent is the only way to read the document. So if you've got a living document individual, such as Woodrow Wilson, he comes along and says, oh, well, that word doesn't mean the same thing today as it did back then. So I can change the meaning of the Constitution because it has to keep up with the times. It's a living document. You just reinterpret it according to how you need it. That's not the law. That's the will of the man who's doing it, or the woman. And that person should be immediately removed from the bench. and kept as far away from public service and the law as possible. Original intent means the original intention has already been defined by the people who wrote the law and put it into play. You go back to their original intention. The founding fathers said that that is the only way to interpret the Constitution, according to the way it was originally argued between the Federalists and Anti-Federalists, as it was understood in Congress and in the Constitutional Convention. That's your stare decisis right there. They've already told you what it means. So if you're going to come along later and say, well, we have the right to limited gun control. No, you don't. That's already been established. That's stare decisis. Well, Joe, it only makes sense. Swing and a miss. But that's how we allow people to do things. In a case in which the framers have already settled something for us, the only way the Constitution is law is in their frame of mind, how they required it to be understood. Otherwise, what happens is stare decisis is used to amend the Constitution without going through the process of amending it. Woodrow Wilson come up with his living document doctrine because it was too hard to amend the Constitution, in his opinion. Well, that's the whole point of the matter. The system was designed to be difficult and to change and to take time, to slow you down and hopefully allow reason to take hold of emotion. Now, we've used stare decisis as a way of abrogating previous rulings and as a way of essentially stealing the legislative power and the executive power from the other two branches of government, and to amend the Constitution without having to amend it. The courts do this all the time now. Then there's this other thing called standing, and this is part of what's going on right now. This is part of what the courts are using to get in the way of the executive. And this is subversion. This is legal subversion. I do not have to impeach you to arrest you for subversion. There is nothing in the Constitution that says a judge must first be impeached before they're removed. Nothing. The only place in our entire legal system where you must impeach somebody before you can then criminally try them is the presidency. So now standing. This is a case of, do you have authority to file a lawsuit, rather? It's not just anyone can file a lawsuit. It's an established piece of, and we got a lot of people filing lawsuits that have no standing. And it's not just, okay, the first thing you have to do is you have to prove that you have suffered a real injury or imminent injury. It's certain, the likelihood is so strong as to almost be a certainty that you're going to incur a real injury, physical or financial. And it has to be concrete and particular. In other words, this is the injury and it's particular to this case. There's no sweeping, oh, well, this might happen type of lawsuits. You can't do that. And it has to have causal connection. So let me use another example here, one that might be legitimate. I'm going to sue the gun company because they made the gun that got me killed or got my relative killed. Do I have standing? Okay. Did I suffer a real injury? No, actually, I didn't. What? Your relative got killed, Joe? Yeah, but I didn't suffer a real injury unless it was my spouse and I lost the benefit of their income. I didn't, so I can't show a real injury. Well, emotional, Joe, that's not a tangible injury. And this is part of standing. It has to be a real and tangible concrete injury. Now, can I show concrete, and let's just say it was my spouse and I've lost access to that salary. Okay, now that's an injury. The law would accept that as an injury. Can I show concrete evidence that this action here, that the gun company was the one who killed my spouse? And concrete, and it's particular to this case? No, I can't. And can I show causal connection that the gun company is the one who caused my spouse to be shot? No, I can't. So those cases should never be allowed to come in court Yet judges allow that all the time. Those judges should be removed. Subversion of the legal system. It's not allowed. Now, I understand that this is going to be like, well, Joe, who's got to be held responsible? The person who pulled the trigger, moron. Are we going to sue the hammer company because I killed you with a hammer? Okay, fine. We can play this game. Let's do reductio. Reduce things to absurdity. Who do I sue when I murder your spouse with my bare hands? Well, there's nobody left to sue but you, Joe. Ding! That was the causal connection right there, the person. Also, standing is designed to limit judicial powers as well. It prevents usurpation of authority of the legislative and executive. And you have to have standing as the individual. You also have to have standing in that court. We'll get to that in a minute. That's jurisdiction. And the courts can also do what's called political exclusion. They can claim that. What that is it doesn't mean that they won't hear a political case. It means that if the case is going to be such that they are going to have to step on the just authority of the presidency or the Congress, they'll say, well, I can't hear this case because separation of powers prevents me from ruling on that. There are a lot of cases right now going on with Trump where the courts should be doing that and they're not. Now, this is where it's really being just like a friend of the court briefs and things like that. I'm going to file on behalf of so and so. That's an usurpation of the system. You shouldn't be allowed to do that. You're not the aggrieved. You cannot show I'm filing on behalf of the illegal immigrants. Show me their ACLU where you're the one that's been harmed. Well, I'm filing on behalf of them. They've been harmed. Show me where you, ACLU, have been harmed. Can't do it? Out of my courtroom. Get gone. If the ACLU wants to help the aggrieved individuals, give them the money and let them hire a lawyer. And, oh, wait a minute. They might not do that with that money because they'll be under no legal obligation to do. Oh, they're not going to do that. Why? Because the ACLU doesn't want to help the illegals. They got a different agenda, et cetera, et cetera. If you are not the one injured, you should not be before the judge. That's an established part of standing. We've just thrown that out the window. Now, jurisdiction. A court does not have the authority to hear any case it wants, and yet they're doing that. I live in Texas, and I want to protect Texas illegals. So what do? I go to Washington, D.C. to sue. Well, if you're suing the federal government, that makes sense because that's where the presidency resides. But if I'm suing ICE, who's operating out of Texas organization, Texas locations, I don't get to go sue the federal government. I don't get to sue ICE there. I have to start with my most local jurisdiction, but they don't. They jurisdiction shop. And what they're actually doing is judge shopping. Now, even if you are legitimately in the right jurisdiction, judicial jurisdiction, does the court have authority or the power to hear the case? Not always. It doesn't. There's a hierarchy of these things. And a lot of courts are taking cases right now they have no jurisdiction to hear. That bald-headed Fruit Loop in D.C. has been taking a lot of cases. He even told them, the plaintiffs, to go back and redo their filing so that he could hear it, so he could defend hearing it. That right there should have recused him from the case. He showed a bias. What he should have told the plaintiff's lawyers is, you screwed up the paperwork. Go back and try again. That's what he should have done. Said, you got this wrong. Go back and try again. He shouldn't give them advice. The minute he does, he's taken side in the case. So a jurisdiction, they don't always have the authority to hear the case. They don't always have the power to hear the case, the ability to provide remedy. And finally, and this is the jurisdiction's one that's causing a lot of trouble right now. And finally, the idea of judicial review. I told you, this is where it all comes down to. This is the notion that the courts have authority over the legislature and the executive to be the final say on what the law says and doesn't say. The idea that the courts are the last arbiter, the last word on what they can and cannot do, and then turn around and hand down remedies. Say, well, okay, Trump, it's unconstitutional to do such and such with the illegal aliens, so now you got to release 600 of them. You can't do that. You can't do that. You do not have the authority to tell the executive how to handle that. You don't. And yet they're doing this. No authority whatsoever. That's the executive's authority. They're even trying to tell President Trump's DOJ what type of cases they can file. They are taking the position of the chief prosecutor as a judge, and then saying you can't file. They're acting as the attorney general. These judges should just be removed for subversion. The penalty is, I think, $10,000 or 10 years. Slap them with both for every act. Run them consecutively so we can get rid of these people and keep them as far away from the halls of power as possible. All right. This is from congress.gov. So it's an official website. Summary. Article 3 of the Constitution establishes the judicial branch of the federal government, creating a federal judiciary with significant independence, providing federal judges with life tenure, and prohibiting diminution of judges' salaries. However, the framers also granted Congress the power to regulate the federal courts in numerous ways. Now, I don't care about what Congress thinks they have the authority to do. I just wanted to post that to show you that they admitted it. They admitted that they have this authority. Folks, the United States Constitution, this is from, let's go all the way up here, National Archives. So this is an official website. So back down to section 3, that's Article 3 rather. Whoops, Article 4, Article 3, Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Where does it say that you have to impeach them to remove them? It does not. It says that they hold their office as long as it's good behavior. Now, so, well, Joe, you got to impeach them to prove bad behavior. That's the common law, but that's not what it says here. Congress has the authority to establish a court. Well, if you have the authority to establish it, you have the authority to alter or abolish it. So if you have the Ninth Circuit Court of Appeals and it's gone rogue, all I need is a simple majority in the House and Senate to abolish the Ninth Circuit Court of Appeals and then reform it with all new judges. Why don't we ever do this? It's a simple remedy. It doesn't require 3/5. It only requires a simple majority. Let's keep reading. Section 2. The judicial power shall extend to all cases in law and equity, meaning financial money, real harm, arising under this Constitution, the law of the United States and treaties made, of which shall be made under their authority, to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies for which the United States shall be party, to controversies between two or more states, between a state and citizen of another state, that's United States, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or citizens thereof and foreign states, citizens or subjects. In all cases affecting ambassadors, other public ministers, consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all other cases before mentioned, the Supreme Court shall have all appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. The Congress shall be able to have the power to limit what the courts can decide. So Congress can tell the courts, you have no authority to look at this or that or to rule on this or that as they decide. The Supreme Court's already acknowledged this, and it was part of the very argument that smacked down old Baldy in D.C.'s first injunction against throwing that daggum illegal alien terrorist out of the country. You know, the one where, hey, you got to bring him back. Well, he's already in another country. Too bad. You got to go get him again. That guy. Well, that got to the Supreme Court. Supreme Court smacked that down, and yet they brought him back anyhow. That's because Trump's a wussy. He shouldn't have done it. It says the trial of crimes, except in case of impeachment, shall be by jury, and such trial shall be held in the state where said crime shall have committed, but when not committed, blah, 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 blah. Section 3. Treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. When BLM says down with the United States, when Antifa says down with the United States, when a sitting member of Congress actively incites an insurrection against the duly elected and installed president of the United States, when the left is running around calling him a fascist, saying that we've got to get rid of fascism, calling him Hitler, inciting insurrection, that is adhering to the enemies of the United States of America. That's treason. No person shall be convicted of treason unless on the testimony of 2 or more witnesses of the same overt act. I've got plenty of that. I got video of this. Everybody who's watched the video is a witness. Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood. In other words, you can't convict any of descendants, just the person who did it, or forfeiture except during the life of the person attainted. So the remedy for these judges is simple. Congress should either limit what they're allowed to hear and the authority of that they have to issue some sort of redress of grievance, or Congress should just, if they don't want to impeach them, they don't want to arrest them for subversion or sedition, just to dissolve their jurisdiction. Just dissolve it and then replace it. Just do away with it. And maybe in the future, the people, instead of my team, rah, 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 R and a D, fight, 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 when you're trying to confirm judges, maybe you should pay more attention to who the heck you're putting on that bench and stop rubber stamping their approval. Because an activist judge shouldn't even be allowed under the bar. If you're an activist, by definition, you cannot be blind to justice because you've already shown you have a political bias, and the judiciary is supposed to be apolitical. Now, we all have biases, yes, but so long as all of a judge shows is a legal theory bias, that's at least a little bit more acceptable. What do I mean by legal theory bias? Well, the Constitution's a living document. No, it isn't. That's a legal theory bias. You should not ever confirm any judge that adheres to to the legal theory of a living document. Because if it's a living document, it means whatever the heck it means to the person reviewing it at that moment. And then what you're saying is might makes right. Because if you're the judge reading the Constitution and you read it any way you want, I'm the citizen reading it, and I read it different than you. Well, I'm the judge. I get to say, Joe, I'm the citizen. I'm the one who gave authority to that Constitution. I actually have more authority over it than you do. Well, that's not what the Constitution says. I don't care. It's what I say. Now, how do you decide? It's going to become might makes right. That's not natural law, natural rights. That's not constitutional government. That's the law of the jungle. We should dissolve a lot of these jurisdictions we have in this country. A lot of these courts should just be done away with. Just dissolve them. And replace them with judges that understand strict originalism. That's the only way to interpret a constitutional system of law. If you're going to do it by common law, You're making law with every case you hear. You're not determining law, you're making law. And if you're making law, you're the legislature, not the judiciary. I understand the common law system. I have no problem with it when it's executed by judges who work that way. But if you're not going to adhere yourself to the way the law was administered in the past, and they don't, then it's not common law anymore. It's just whim with an occasional nod to tradition. And you're right in the smack in the crosshairs of Madison and Jefferson's concerns with the judiciary. Ultimately, folks, this is our fault. We've allowed this state of affairs. Charlie, anything to say before I call it a wrap?
Well, no, other than it's a mess. But it's true. I mean, the judiciary,
what a tangled web we weave.
Yeah, the judiciary has assumed all control, and Congress
they've been
and
allowed
the executive are ceding that control to them.
Yes,
because the president is, where he could be standing up to the Supreme Court on a lot of these issues, and
or
saying,
the lesser courts.
I don't care. Well, yeah, or the lesser courts, but particularly the Supreme Court, because that's supposedly the highest court in the land. But he could tell them, "Sorry, I disagree with your decision." And then, I mean, if Congress thinks, well, we agree with the Supreme Court, then pass a law that supports whatever that is.
Right, and override the president or impeach the president.
That's the way this is supposed to work. But they're ceding their authority to this group of people that are unelected and are there for a lifetime. That's one of the problems I think we have with this is, once they get in there, they can do whatever the heck they want, because what are you going to do to them? You can't. The only thing you can do to them is, they die.
Yeah, but you can't.
Although you can actually, like you showed, there are ways to, remove judges. But
the problem is, if you make the judge a political,
we're unwilling to do that.
Right, and if you make the judge a political seat, like in Florida, where we have to vote to retain them,
yes,
or get rid of them. Well, now you've just made the judge a political character.
Yeah, right.
So the people, the Constitution says that you must impeach the president. Now, it was a matter of common law that you had to impeach a judge. The Constitution, Charlie, we just read Article 3. Did it? Nothing about it. Just says they hold it for as long as they have good behavior.
Good behavior, right.
It doesn't say jack about how you get rid of them.
And it doesn't say, like you said, that it shows that Congress has the ability to create those districts and things like that. And they can, like you said, they can
the Congress
dissolve
has to
them and recreate them, and we can do
Congress
all that.
has to confirm a federal judge. Why doesn't the Congress just say, we revoke your confirmation?
Yeah.
Just in a simple
vote
too.
Yeah.
Well, Joe, that's making law. Yeah, in the Congress. Guess which body of our Constitution makes law?
Yeah, they're the ones that make law.
So if they make it and the president signs it and it gets to the Supreme Court and the Supreme Court says, oh, well, now that's unconstitutional. You say, well, sorry. Well, no, I've got judicial review. Exactly. And when they say it's unconstitutional, you say, well, sorry, you have to recuse yourself because we're actually talking about y'all.
Right. And show us in the Constitution where we can't do this. It's not there.
The way our system works, if the Congress passes the law and the president signs it and the judge says, well, I'm sorry, it's unconstitutional, that's 2 against 1, Jack. You lose. What do you mean it's 2 against 1? It's 3 co-equal members, 2 of them saying this is legal, 1 of them saying it's not. Sorry, you lose.
Yeah,
that's constitutional by the people who wrote and enacted and now enforce that law.
Yeah, that's a good point. Oh. Our sniper gets to do some work now.
All right, folks. Tomorrow, the next 2 chapters of We Who Are Lost, Unseen Realm by Dr. Michael Heiser. And the final announcement on what's going to happen next week. I'll have that done by tomorrow, even if I end up putting off other chores I should be doing today to make sure that happens. It's a promise. We love you. We thank you. Appreciate everything you do with us here, that you give us your time. We hope we're teaching and edifying and educating in some way. This is a complicated subject I tackled today. A lot of your lawyers and judges will tell you I'm wrong. No, I'm not. I'm attacking the theory of the law, not the bastardization as it is they've made it and now defend it. Just like I don't think there should be a bar. The founding fathers didn't have a bar. That's a civilian organization that decides whether or not you have permit. It's a union for lawyers. Do away with that crap. Well, then you might have people practicing law who don't know how to practice it. No, what they wouldn't know how to practice is the bastardization you've created. Anybody who understands common law can practice law. Anybody. That's part of how the system was designed. So it's my plaque says shut my mouth when I've said enough. We love you. We thank you for being here. See all y'all the next time we see you. Bye-bye.